Hi, David Campanile here, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate. As always, before we get started, if you have any estate planning or probate questions, contact me at njestateattorney.com. I'd love to set up some time with you, discuss your estate planning and probate issues. So today's topic is something that you don't see a lot in the estate world, but it does happen. This is about insolvent estates. And the reason I wanted to talk to you about this is I'm actually personally going through this. And I thought, this is something that I've spoken to several estate planning attorneys, and they're like, this is something we really rarely cross. And I thought, since it seems to be rare, it's still worth talking about. So, just to begin, you usually have what's known as a solvent estate or an insolvent estate. And basically what that means is solvent means there's enough money in the estate to cover all the debts of the decedent. And what I mean by that is the debts are equal or less than the amount of money in assets. Basically what you do in a solvent estate is you would pay off all your debts after you accumulated them as the executor. You go to the court, say, hey, I have to pay a check out to Verizon, I have to pay a check out to American Express, I have to pay these bills, and then everything else goes to the beneficiaries. In an insolvent estate, we kind of have, we turn this upside on their heads a little bit. And what happens here is, because we don't have, in an insolvent estate, we don't have enough money or assets to cover the costs or debts of the estate. So here in New Jersey, we basically created a statute that says, all right, here's the list in order of how people will get paid out. And it starts with reasonable funeral expenses. And basically what the court is looking at is like, hey, you didn't spend $50,000 on a funeral, but the expenses were deemed reasonable. In my circumstance, we opted, instead of burial, we opted cremation because that was what I was directed to do. And that cut costs down. So the court really can't argue because I took an easier or cheaper route for the estate. The second would be costs and expenses of administration. Now, this would be the attorney you've hired, any accounting, and your executor, because the executor still gets a fee under the statute. And it's 5% up to the first $200,000. And anything after that, we go down a sliding scale. So those would be your three administration costs and expenses. Normally, we get an accountant because we need to make sure that all taxes have been paid off, make sure the IRS and the state are handled. Your attorney does not get paid a retainer, actually. The estate will end up paying them at the end. It's the responsibility of the executor to pay the attorney out of the estate. And then the executor gets paid as well. Your third are debts for the reasonable services rendered, if you have it, by the Office of the Public Guardian for elderly adults. Basically, there is an office in the state of New Jersey that they are guardians for elderly adults, and they would get paid next if they were the guardian. Then you have debts and taxes with the preference under the federal law or the laws of the state. So basically, now you're going to pay your taxes to the IRS and your state and the state of New Jersey. That would be the next one. Then you have your reasonable medical expenses and hospital expenses of the last illness of the decedent, including any compensation of persons attending him or her. So basically what this is, the event, if the person was in the hospital or medical, that caused the person to die. It can't be what's led up for months and months. It would be that last final time. Then you'd go into judgments, if there were any judgments against an individual, according to priorities, how they were entered. So based on the date that judgment was entered, you can have people that have 10 judgments, but the judgment that was entered the earliest and filed appropriately would get preference. And then any and all other claims, these would be what people in bankruptcy would deem unsecured creditors. Basically, they're just jumping in at the end. When you go to file an insolvent estate, we'll talk about that a little bit more in another video, but I really just wanted to get the statute out there for you. I wanted to break it down a little bit, try to make it clearer to see, so you can understand how this is paid, the order it's paid, and really to see the difference between a solvent and insolvent estate. I hope you found this video helpful. I'm going to be going on this a little bit more. It's kind of like a two-part kind of thing. If you have any questions, comments, please reach out to me, njestateattorney.com. I'd love to schedule a free strategy session with you to discuss your estate planning and probate questions. If you felt this video was informative, please pass it along to people that you know are handling estate plans, are in the probate process. Maybe they need a little help in this regard. I greatly appreciate that. As always, I'm David Campanile, owner of Campanile Law, located in the state of New Jersey. We handle estate planning and probate.